These are really old.
Yeah, but these were way better.
Yeah.
All right. Let's see. Shelby Hall, what did you and Alex talk about? Or were you with Kelsey and Emily?
We talked about like the paragraphs that are small. So like he breaks it down into like 1 and 2, but then his like point 1 is made up of like 5 smaller paragraphs instead of any big long.
Can you give an example?
Yeah.
Can you finish to a page?
So like for A on page 13.
Yep, and 124 of the supplement.
Yes, and then he starts with point 1 under A, and so instead of being like any really long paragraphs for 1 and also 2, it's like 5 smaller paragraphs that all break down that still point A or point 1. And so it's like kind of refreshing, like you can just kind of read through a small chunk of it and then go on to the next part, and it's all related, but it's not like you're getting drowned in this big long paragraph for his point number 1.
Good, good. I like that. I also like that same paragraph that Shelby was talking about. He quotes the text. Never a bad idea to start by quoting the text. He also goes general to specific, and that's true for that paragraph, and then also just for the larger structure. I think, again, he gives an example of how to spend a paragraph or 2 paragraphs on a single precedent. If you look at page 15 of his brief, 126 of supplement 2, he spends a paragraph there on Crawford. Then he spends a paragraph or 2 on Davis. So again, you can use those as models when you're thinking about how to spend a paragraph on a case when you write. I just kind of like, if you start at the very beginning, 123 of the supplement, page 12 of his brief, go through a couple things I liked, and then we're a minute or 2 behind, so we'll move to the oral argument. But he begins with an implicit response to the counter argument he says, we are not asking for a rule that would reverse 200 years of precedent, but he does it without even mentioning the counter argument. So this is like almost like the ultimate Jedi way to like respond to a counter argument. Make your main argument the counter argument to theirs. So he begins with that. If you look at page 125 of the supplement, it says, nonetheless, this court has provided considerable guidance concerning the concept as a starting point. What is he doing there? He's going to explain the rule before he does application. So it's something as basic as CREAC is at play, even in a complex appeal like this. We talked at the bottom of that page about the nice quote that the defendant might want to use in its brief in our case. And then once he has done rule explanation, which is basically subsection 1, then on page 16, subsection 2 is rule application. So rule explanation, then rule application. If you look at the next page, he kind of does a little bit of going back and forth, rule explanation, rule application, but in general, pretty good. And then look at page 18. Who's that? Sam here? Sam's not here. Emily Hart. So page 18, that first full paragraph, that first sentence, such is precisely the case here. What writing principle do you think, and there are several to choose from, are illustrated there?
Among other things, the overuse of the unnecessary ly verbs that we just learned about in the Judy Fisher.
I can kind of see that. Maybe he should have just said such is the case here. I kind of like that. Anyone else? Anything else? Just like in the Greg Garr topic sense we talked about, there's a bridge. There's a bridge to the previous paragraph. Such is pointing word. That thing I just talked about, such is precisely the case here. Also, short sentence, so varying sentence length. Okay. So let's listen to an oral argument here. But I'm going to set it up a little bit. Why are we listening to this? So this case, so the way it worked was, oh, by the way, Jeff Fisher's brief here, probably drafted by 2 L's and 3 L's in law school, because he's running a law school clinic there. So a good example of no matter how junior you are as an attorney, you can still find interesting work and do important work. And they win, and they change the law here. This was Melendez-Diaz in Massachusetts, or Massachusetts v. Melendez-Diaz, I forget who the petitioner was. And Greg Garr is the Solicitor General for the United States. So why is he even writing a brief here? Anybody would guess? It's an amicus brief, which anyone can write. If you have an interest in a case, you can file an amicus brief and say to the court, amicus means friend, amicus curiae, friend of the court, and say like, hey, this case affects me in some kind of indirect way, so I want you to know what I think. So since the federal government prosecutes people all the time, this obviously affects them, so he filed an amicus brief. So he would have gotten some argument time, but he wouldn't have been the main person arguing. And then Jeff Fisher, we could listen to the defendant's side, but we listened to Jeff Fisher last class. So we're going to listen to Martha Coakley's argument. She represents Massachusetts. We didn't read her brief, but she is the main party on the prosecution side of this case. And so as you listen to it, we're going to listen to 3 quick clips. Think about everything we always think about, but also think about why are we even listening to this at all? Why are we listening to this? Okay.
In footnote 10 in your brief on page 30, and you concede that some interpretation of the machine-generated data ordinarily is required. Now, why isn't that a suggestion that there is some leeway in subjective interpretation, and you might have different analysts coming out differently, and so you need to get the fellow there and ask him, well, how often do one of your fellow analysts disagree with your conclusion?
Remember, she's on the prosecution side, so she's on the Greg Garr side, so she believes that this evidence should be used without having to call the actual witness. So she's saying the Confrontation Clause does not prevent us from just submitting this test into evidence without calling anyone from the lab who actually ran the test. That's her argument.
This is subjective. I guess some people are going to read it one way or the other. Which way do you always read it?
Well, interesting, that argument wasn't raised in this case below and really hasn't been raised in this case before the court. In fact, this is one of the more straightforward objective tests that says you put this material into the machine, and the Solicitor General also deals with this. The 100% accuracy by and large from that result says this is cocaine, this is heroin.
Well, I didn't go back and read the scientific treatise you cite, but you say some interpretation is required. So what type of interpretation?
The interpretation is that because the way that the machine works, the chemicals are separated out, and so a chemist who's properly trained can say, by the separation of the chemicals, these 3 or 4, or whatever the elements are, equal cocaine.
Well, do you have to have a machine? I mean, what about ballistics? This bullet came from that gun. Does that involve sufficient discretion, sufficient judgment that the expert has to be there while the blood or drug testing doesn't? It seems to me that's where you have to draw the line.
Well, I believe that
And to say that wasn't raised in the case, this is precisely the question we're going to have to decide if you're going to prevail. I don't think it helps to say it wasn't raised in the case.
No,
You're raising it.
I agree, Your Honor, but that has to do with how.
All right, so let's stop there. Thoughts?
Well, so ballistics, that's like a whole different, that's like a trained skill. So what she's talking about is you put it in, it's like a microwave. So you put the thing in, it's going to come out cooked. So it's real easy. Like.
Good. So I think what they're asking for is an answer just like that. So they're saying, okay, we need a test. Like, we need a legal test that will distinguish between things like ballistics, where it really might matter who the expert is, and this cocaine test that you say, any 5th grader could run this test. And so they're looking for that kind of like a legal test to try to like inquire into that. And what kinds of questions are these in terms of the categories? Yeah, Priya?
I don't remember what you called them, but like help.
Yeah, help me help you questions. And you can tell not just from the substance of the questions, but as you get into more of your research, you'll see Roberts, Kennedy, Breyer, they're on her side. they hate the confrontation clause. They don't want to rule for a criminal defendant. In fact, just I think this week or last week, Breyer, who was a Democratic appointee, sided with 4 Republican appointees to rule against a criminal defendant, and even John Roberts was in dissent. And he doesn't wake up in the morning and think how am I going to help criminal defendants today? Even he would, but so how Breyer is not Breyer's on her side and Kennedy's on her side and Roberts on her side. They're looking for some help so that they can get to the result that they want to get to, which is the result she wants them to get to. But she has to prepare. So that's the main reason that we're going to listen to these 3 clips is preparation, preparation, preparation. I think these questions are very expected questions. These are not trick questions or surprise questions. She should have been prepared for these questions, and she should have had better answers prepared. Oh, and then also, what do you think, Taylor? What do you think of the way she started out? He says, blah, 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 and she says that argument wasn't raised in the case below. Think good answer, not so good answer.
I would say not.
Not so good answer. And one of the ways you can tell it's not so good an answer is because later on, Justice Kennedy is like, I really hate that answer you gave. And to say that wasn't raised in this case, this is precisely the question we are going to have to decide if you're going to prevail. So I don't think it helps to say it wasn't raised in the case, we are raising it. So he is bashing her, but he's also pointing out to her if you want to prevail, by the way, and I want you to prevail, we're going to have to address this. And so it's perfectly fine to say that a claim wasn't raised below. Sometimes claims do get forfeited or waived, and appellate courts should be respectful of that. But there's just between a claim and an argument. So the claim that the confrontation clause was violated was definitely raised below. That's why we're here. And so maybe this specific argument wasn't made in support of that claim, but the court can still consider that argument. So it was an unhelpful thing for her to say. Okay, let's fast forward a little bit to, where are we, 43, 52. And start here.
I do wish you would comment on the argument that the state of California, a huge state with many, many drug prosecutions, seems to get along all right under the rule that the petitioner proposes.
Okay, so note this question. Again, a completely expected question. There was a brief filed, and it pointed out that in the state of California, they don't admit into evidence these tests unless the lab technician testifies in person. And the sky hasn't fallen. It's not like the wheels of justice have grinded to a halt. It's a big state. They've got a lot of prosecutions, and they're still doing just fine. Prosecution is still doing just fine in California. So if they're doing just fine in California, why won't they do just fine in Massachusetts? And Coakley's, one of her main arguments is our wheels of justice would grind to a halt. If we have to always call these people, it's going to be delay and difficulty, and guilty people are going to go free. And this is just total form over substance, and it's inefficient, and we can't do it. And so her opponent says, well, they do it in California just fine. So Justice Kennedy, who's on her side, says, help me get past that. So let's see what she says about that.
They've joined the amicus brief, Your Honor, I believe, so I think it's too early to tell because I certainly from my own experience know that the number of cases that go to trial is not an indication of what the work is that is involved. And I know that in Massachusetts
if the state of California and other populous states have for, I take it, some number of years been able to function quite effectively under the rule that the petitioner proposes, it seems to me that's something that you have to address.
I address that, Your Honor, by saying that for Massachusetts it would be an undue burden with very little benefit to them.
Why would it be undue for California and not for, are you accepting the fact that in California it's a workable rule and it's caused no problem?
I can't disagree with that, Your Honor. I don't have enough information about the way California works. It doesn't work. I know that is a practical matter.
It seems to me it's a very important point.
Yeah, so he asked the question 3 times. Did she ever answer the question? And it's a basic question. Why, if it works in California, will it not work in Massachusetts? And sometimes these judges ask questions that are not clear. They don't phrase them. I think he was pretty clear each time. And she just has no no answer for that. Once again, she's unprepared. She could have anticipated it, but her answer is, at the end of the day, I don't know. I don't know how California pulls it off, but we can't pull it off in Massachusetts. Not a good answer. And then she makes this conclusory argument, well, it's an undue burden for us, but then that just raises the question, well, why is it not an undue burden in California? Also do one more, 47. Find that.
What if it's the central issue in the case? The defense is that stuff I was carrying was not cocaine. Either I was trying to, I was going to stiff the person I was selling it to or whatever. That's the sole defense. That's not cocaine. All you got to do is submit an affidavit from the lab guy saying, I tested it, it is.
Well, from the prosecution's point of view, that would be a bad strategic decision.
First of all, does she answer the question?
And that's an instance where you would bring in the analyst because you want...
But that's a non-answer. We're asking, what's the rule?
The rule...
And you submitted on the affidavit, as the Chief Justice said, under your theory of the case.
Yes.
You try to have some different hypothesis.
Yes, because the defendant has plenty of opportunity to both have an independent exam, to subpoena the witness in himself, to make sure that if that is a true issue at trial, in many instances, most instances it is not, then he will have the opportunity to cross-examine.
Thank you, General.
Okay. I think, again, she failed to answer the question directly. Did you find what she's doing now?
I did.
What's she up to?
So she has not run any she's not been in any political campaigns since her 2014 gubernatorial loss in Massachusetts. She is now a partner at Foley Hogue, focusing on administrative law.
Okay. So here's some background on Martha Coakley, who I suspect is a very talented attorney, and a person who's probably like doing great at her current job doing administrative law. But she is not. She does not have a lot of experience doing this. Right? She did trials, and then she was a politician. And so, what if you're her and you have a case that's important? What should you do in that situation? You have an oral argument coming up for the Supreme Court, and let's say, for example, let's say you have, let's say you pick up a client, and you thought it was going to be kind of like a run-of-the-mill case, but then it turned out to be like life or death, or like bet the company litigation. And so, and you, in order to win, you need to do something well that you've never done before. Yeah.
Pass the ball to a better player.
Maybe so. I mean, I don't think that's always the answer. I think sometimes the answer is you just find a better player and you prep and prep and prep, and they train you like, Rocky style.
Yeah. And
then you go hit the ball out of the park. But sometimes you don't have the time to do that. And sometimes you don't have the inclination, the desire to do that. And if that's the case, then, yes, pass the ball to somebody who has experience doing it. And she's the Attorney General of the state. It's not like she's a solo practitioner. She's got plenty of other attorneys she could have had do this case who may have a lot more experience than her. Why do you think she chose to do it? Yeah, Emily.
Because it's arguing in front of the Supreme Court.
Yeah, she probably did it for the glory of it. And her client was not particularly well served by that. We had a Commonwealth attorney in Jefferson County a generation or so ago who tried the Mel Ignato case. Does anybody know the details of the Mel Ignato case? So you're nodding. So Mel Ignato committed a brutal murder and got acquitted, in part because the prosecution put on a really bad case. And then later they found photographic evidence of the murder in his house. So it was clear that he had done it, but he couldn't be prosecuted for the murder because of double jeopardy. They ended up prosecuting him, I think, for perjury. But why did that prosecutor botch that case? Well, partly because some Commonwealth attorneys are probably great trial attorneys, but the job of the Commonwealth attorney is not to be a trial attorney. What's the job of a Commonwealth attorney? It's to get elected and to manage a large office in an effective way with vision and strategy. And those are important skills that a lot of people don't have. A lot of great trial attorneys don't have those skills. But a lot of people who have great management skills don't have great trial attorney skills. So what he could have done was find someone who's done 100 murder cases or 20 murder cases in his office and say, you should try Malgado. And then maybe justice would have been done there, but instead he wanted it for himself. He took it himself and he botched the case, yeah.
In both of those situations, those are people who are in a position of authority.
Mm-hmm.
So what happens when you're not in a position of authority and you think you can do your job and you want to gain the experience and you do want to talk to someone who's more of an expert in that, but there's a risk that you have the case taken away from you by a firm, you know, or like how do you sort of protect yourself and advance your career while doing the best for your client and not?
That's a tough question. I mean, I think that probably my advice would be the client comes first, even over your career. Hopefully you're at a place where you can get advice and training and guidance and not have the case taken away from you if you're capable of doing it. But I have a friend who I co-clerked with, and he had his first Supreme Court argument a couple weeks ago. He was fantastic, but it shouldn't have been his first. It should have been his second. He took a case from beginning all the way up until the Supreme Court oral argument, and he would have done an awesome job, but there was a partner at the firm with more authority, and the partner was like, I'll take that case. And stole the case from him. So it's like, unfair. I would try to put the client first, but hopefully you can put the client first and still get experience. I mean, it's in a firm's interest for you to eventually get that experience because associates need to become qualified to be partners. Yeah.
Boss, win or lose?
That's a good question. I don't know that. I don't know the answer. I don't know the answer. It's been a couple years, so I don't even know what the case was or who, other than him, I could ask. That'd become an awkward question. So I think the case that he recently argued has not been decided yet. But he really was. He went up there with no notes. He didn't even bring a single sheet of paper, and he was awesome. Okay, so we're a little low on time. We're definitely not going to have time for the Garner game, but we do have time for the rest of the story and the vote. And then what I'll probably do is prep you for the reading by emailing you some background. Do we have a vote today? Maybe we're off the hook. Maybe there's no vote. No, there is. Yeah, Gar versus Fisher. Okay, so who has Gar?
I do.
Okay, great. So Zach, give us a quick rest of the story.
The rest of the story is they decided that it was testimonial evidence because it was going to be used at court. It was done to be used at court.
Yep.
So Gar ended up losing.
Great, exactly. Unanimous or split decision? Do you remember?
I don't remember.
5-4. Very divided
think it
court,
was split.
and kind of a foreshadowing of division and confusion to come. Okay, good. And let's see. So Fisher, who has Fisher? Any more of the rest of the story?
Just there was a concurrence. I thought it was 6. Is it 5-4? I didn't know if the concurrence was.
Oh, you know what? I bet that Thomas concurs.
Yeah.
I bet it's 5-4,
And
but then
concurrence.
one of the 5 is Thomas. He always concurs on this confrontation clause stuff because he has a weird approach to everything, but he has a weird approach to this too.
And then it reversed the last one. So he was coming off a loss, I guess, right? It was a reverse in the previous decision.
Was he in dissent in Davis and Hammond? Is that what you're talking about?
I'm talking about wasn't this decision reversed?
I see. I remember. But so it sounds like Massachusetts loses at the Supreme Court and they won below is what you're saying. Okay. Okay, good. So Zach, tell us why we should vote for Greg Gar.
Well, we already have one Fisher, so we don't need 2 of them.
Spread the wealth.
Yeah.
That argument will succeed with some audiences.
I just think it was easy to read. It was more fun to read. The way you kept talking about machines versus humans, I thought was a little interesting.
Mm-hmm. Yeah, good theme. All right.
I just thought it was really well written. It had better spacing. Each paragraph was easy to go through. He won the Supreme Court, and then just the topic sentences and overall, just a good argument. He kind of dissected it right as we had it on.
Okay, good. So let's vote. Who votes for Greg Gar? Chris, be pretty close. 1, 2, 3, 4. Maybe not that close. 5, 6. Dimitri's like up and down here.
No, I'm just up.
Okay, I think he loses anyway. Fisher, who goes for Fisher? 1, 2, more than that. So, Fisher, again,
Tried to help you, bro.
fails. I liked your argument, Alex. Like, the spacing is good, and he won. So,
Always
tough argument. Okay.